Welcome everyone to one more edition of the Privacy with Live Talk. Today we are here with Professor Solove. He doesn't need any introductions, but I will talk a little bit about his amazing, incredible, groundbreaking work in the privacy field. So, Professor Solove, welcome to the Privacy Whisperer Live Talk. So, Professor Solove is a professor of intellectual property and technology law at George Washington University. He's president and CEO of Teach Privacy. He's the co-founder of the Privacy and Security Academy. He's one of the most well-known, respected, and prolific privacy scholars of our time, and I'm super honored and excited to be here with him. He has various published books, and I want to tell a story. I have here this book. If you study privacy, if you've ever studied privacy, you know it's Understanding Privacy, and I want to show you that it's still with the markers. It was the first book I read when I was starting my master's. So I got my introduction to privacy was this book. So I didn't remove the markers. Also, if you didn't read, I recommend. Also, if you're starting, if you want to work in the privacy field, if you want to have foundations, it's a great book. One of the if you go so one of the most popular books of Professor Solove, Information Privacy Law, a case book. So this Understanding Privacy, Nothing to Hide, the false trade-off between privacy and security, also breached, why data security law fails and how to improve it. Also, this is about books and about papers. He doesn't talk much about that in his own newsletter and his social, but I'm going to talk about his numbers, his incredible numbers in terms of publications, amazing, very groundbreaking papers and constant, and every paper has thousands of downloads. So he has the most popular paper. If you go to the Social Science Research Network, the most popular paper in the topic privacy is his paper, I've Got Nothing to Hide and Other Misunderstandings of Privacy. It has 220,000 downloads. And on total, he has 420,000 downloads, and he is number 11 of all social science research networks. So, and these are about numbers, and he never stops. So it's difficult to catch up with Professor Solove because he's always publishing. So some of his recent papers that I recommend everyone to check them out. So and they're all available at the Social Science Research Network, so SSRN. Murky Consent, an approach to the fictions of consent in privacy law. By the way, I love that. It was the topic. Consent in privacy was the topic of my master's thesis, where I read this book about. So I love this paper. It's very good, very interesting. Data vu, why breaches involve the same stories again and again. Data is what data does, regulating use, harm, and risk instead of sensitive data. The Prediction Society, they're very interesting. He talks about algorithms and the problems of forecasting the future. So it's also about this intersection between privacy and AI, and the limitations of privacy rights. So all those are from 2023. So we are still in June, and he has published all that. So he's unbeatable. It's difficult to catch up, and he's a central figure in the privacy community. And again, thank you so much, Professor Solove, to be here, for being here with us today. And for those who don't know, I'm Luiza Jarovsky. I'm the author of the Privacy Whisperer newsletter. I'm also the founder of Implement Privacy. And today we are going to talk about another paper that we didn't yet mention, privacy harms. So Professor Solove wrote together with Professor Danielle Citron. It was the paper. It is published in the Boston University Law Review. It was published in 2022. And I think I wanted, the whole story is like this. I wanted so much to hear Professor Solove's opinion about this intersection of privacy and AI. I think it's super relevant for every privacy professional now, with AI hype and AI governance emerging and new challenges. It's still an open question how we're going to deal with them and how privacy harms and privacy issues can intersect with AI. So I think that this paper, it's a great way to start a conversation, and some of the ideas that he and Danielle put in the paper can help us place this debate in a more concrete way and understand specific issues that I think privacy can help AI to stand stronger, let's say like this. So the plan for today is the following. First, I'm going to briefly comment the paper for those who didn't read. And anyway, I invite everyone to read. It's a great paper and super relevant with important topics for today's reality and AI and so on. And then we are going to discuss some questions that are prepared. And the first ones are mostly about harm, exclusively privacy harm. And the next ones, the following ones are more about the intersection between privacy and AI. and then we open for questions. So if you have questions, please write them down and wait for the end of the main discussion. So about Professor Solove's and Professor Danielle Citron's article. So it's split in two parts. So the name is privacy harms, and the main goals that they state, they wanted to first provide a typology of privacy harm to help courts to deal with those issues and to tackle them better. So sometimes we are going to talk about the challenge of privacy harms. They are not the same as maybe traditional fields of law. So the first aim of the paper was this typology to help courts, and the second aim was to provide an approach of when privacy harm should be required and help align enforcement goals and remedies. So a typical litigation issue, sometimes there are no incentives for lawyers, and sometimes we should not focus on giving the money back to the customer. So there are different litigation, let's say, and enforcement issues in privacy harm. So that's the main goals that the paper aims to solve. In the first half of the paper, they talk about the challenges of privacy harms and also the specific litigation issues. In the second half, they talk about the typology, so the 7 types of harms. And just so that we have this clearer picture, these are, I'm going to read the list of harms. So in the paper, there are 7 types of harm. All types of privacy harms. So it can be physical harms, economic harms, reputational harms, psychological harms, and those psychological, they can be emotional distress or disturbance. Autonomy harms, which can be coercion, manipulation, failure to inform, thwarted expectations, lack of control, and chilling effects. Discrimination harms and relationship harms. So this is the base. So we are starting, this is our baseline. We are starting the conversation having this privacy harms in mind. And let's think of how we can move from here and push privacy forward and bring privacy to the forefront. So, Daniel, would you like to comment on something else that I didn't say about the paper, something that you think it's relevant or is important everyone to know before we move to the questions?
Yeah, I thought you did a great job summarizing the paper. And I'll just say a couple things about the paper and its goal. So the purpose of the paper is to better articulate the problems or the harms of privacy, because courts and legislatures we're not really getting it in certain cases, or we're fairly inconsistent about recognizing them. So a lot of the paper is really about focusing on those harms that especially courts could address, and that the law was currently not adequately redressing. So we really were focused a lot on, what are certain harms that we're having some trouble kind of getting fully litigated into the courts. And that was our primary focus, was courts. But secondarily, recognition of the harms by legislatures. So it's very much about what harms could be cognizable in specific litigation to address. And that's what led us to look at these. And for each one, there actually is a basis in the law, analogous other bodies of law that recognize these harms that can arise from privacy violations. And so we really were trying to show that there is a good foundation in the law for this that is often ignored. Or that courts are very inconsistent about recognizing, but that each one has a pretty solid foundation to be recognized, contrary to what a lot of folks, courts and others would say, which is, well, these harms are just too ethereal or just too insubstantial to be recognized, which I think is wrong. Courts recognize these types of harms all the time.
Great. Thank you so much. And so I prepared a few questions for us to discuss, so also for us to have more concrete examples, and also to make this bridge between privacy and AI. So specifically about this notion of privacy harms. And also, you have a paper about taxonomy of privacy, a very important notion. Also, it's also in this book you talk about it. So my one initial thought when I was reading, and it inspired me a lot, is, and we will talk about it. I write in my PhD, I write about the harms, and I try to explain in a different way as well. Uh, why talking about privacy harms now? So do you think so? Where did the idea to write this paper come from? Do you think reality changed, and now we need to the harms are more challenging now, or it's just a litigation aspect that you saw that litigation was failing and was not tackling? So my first question is, where did this idea came from to write this paper with Professor Danielle Citron, that to write this typology of harm and to kind of expand? I think it's an expansion. I think the way you put it in a very nuanced way. For example, autonomy harm, which one type that I discussed in the PhD, you put very subcategories, and it really I know it's in the law, but it expanded. It brought the notion of the harm in a more concrete, in a more even creative way, that will help practitioners and courts to deal with the issues better. But so my first question is this: so why now? So why talking about this typology now? And did reality change, or did courts start behaving differently? And so in what sense do we need to talk about it now?
I wish I had a more profound answer, but this actually the reason why it was published now was because it took us a long time to do it. We started probably around 10 years ago, and Danielle and I were having a conversation at lunch, and it was actually her idea to, we really should write a paper on privacy harms because, courts were just, botching it left and right. And this was after I'd written Understanding Privacy, where I had a taxonomy, but that taxonomy was focused on privacy problems and a way of conceiving of privacy, like what is privacy, and so that taxonomy was really trying to lay out what privacy was. I had certain problems, but those problems actually, each problem could involve many of these different types of harms, and so Danielle and I were talking about, well, the harms you can grab onto, and which would be the starting point for a litigation, or the starting point for passing a law. What do those look like? And we should write something about that. And then we talked about it. We started drafting, but time and other projects and all sorts of things intervened, and then we kind of finally did start writing, and then we realized that data breach harms and the data breach litigation had gotten so voluminous and so many cases, and these were actually had a lot more in common than the privacy harms, which seemed to be all over the place. So we thought, okay, really, where the cases that we were thinking about and talking about were data breach, we should cover those together. And so we wrote a piece called Risk and Anxiety, a Theory of Data Breach Harms. And that was the first piece that we wrote on this topic. And then we said, we still really want to come back and tackle privacy harms. We want to write the paper that we had actually planned to write. Still then more things intervened and so on, and years passed, and then finally we just said, we really got to do this thing. We keep talking about it, we keep wanting to do it. We've kind of done a lot of the preliminary thinking of it, but then we finally just said, okay, we're gonna break ground and build this building. So we did, and it's actually, I think, a good thing that we waited so long. I think what we've identified and the typology that we came up with, I think, is more robust now than it would have been had we done it when we actually started talking. I mean, time really helped us, understand the issues more. There was a vastly greater body of case law and a vastly greater body of scholarship out there that we could draw upon for insight, and that, I think, so I'm glad that it took as long as it did, because I think it's a better piece because of it.
So it becomes an even more special paper when I know now that it took 10 years to be made. So it's a very uh, well thought, and it took a decade to be written with all the insights. So I appreciate it even more. And I'm probably other people that read the paper and read also are familiar with your work and Danielle's work. I could see sometimes I was reading a part. I say I hear Danielle write when the part of the deep fakes and your part when you're talking about typology. It's funny how when you write in four hands like this, I could hear your voices talking. So it was I love to read this paper, and I'm happy to hear that it took 10 years. And we are going to talk about that, and also about one of the most fascinating part, at least for me, and that deeply influenced my PhD work, was the part of autonomy harm. I don't, my personal opinion, maybe you disagree with me, the part of autonomy, and specifically, so one of my PhD chapters is about dark patterns. So the idea of UX tricks that make people share more and more sensitive data. And this body of law, the all reports and also legal changes, they all happened in 2022. A massive number of reports in basically end of 2021 and 2022. And I can see also, and when you talk about autonomy and autonomy harm, and I was seeing a dark pattern, so it fits so well together. So I was very inspired by reading your paper and connecting it with dark patterns. But I hope to talk about it soon. So the second point I'd like to discuss today is about the specific challenges of privacy harms that you mentioned. And the point I'd like to approach it here more from I would call privacy branding perspective. So you mentioned some uh, challenges that make privacy harms cognition difficult, and I will tell what you wrote. So the first challenge is aggregation of small harms. So some privacy harms they become harmful because of the aggregation. So if you receive one email spam, right, one unwanted email is a minor inconvenience, but imagine someone receiving hundreds of unwanted emails a day. It's unbearable. It's horrible, although each one is a small harm. So also is one thing that law has difficulty in dealing with. So second challenge is the unknowable and future harms. For example, data breaches. There's no material harm yet when the breach occurred. We don't know what happened and future uses of data of malicious parties. So also law has also difficulty in dealing with future and unknowable harms. And the third challenge that you mentioned is the individual versus societal harms, so social harms, social aspects of privacy harms. As lawsuits, they usually recognize the individual aspect, and there's also the collective aspects in terms of values, and sometimes even class actions, they don't grasp well these more general societal aspects of the harm. And so I would like to bring these challenges. You discussed a lot in the paper about the how it affects litigation and incentives to tackle those harms and to make them to enforce and to avoid them. And I want to understand how your opinion. How do you think that those issues and how can we, given those challenges, and they exist and probably they will keep existing in the privacy context. And one point that I want to make, so for example, the thing of aggregation. So we usually say some people that they don't, let's say they don't think privacy is something serious or so serious as security. They think security is important and privacy is like an exaggeration. So they say, you privacy guys, you're focusing on unwanted marketing. This is so silly. And so this aggregation aspect is sometimes it's difficult to explain and makes the privacy argument weaker, because you talk about, let's say, consent or agreeing to receiving email, and the other person might say, yeah, but the only problem will be an unwanted email. It's nothing. It's just a small inconvenience. So how can we realign this idea of privacy harms, privacy issues, privacy principles, privacy harms, in a way that also when we talk about privacy and when we explain privacy and we want to tell companies why it's important to invest in privacy, and we want to tell people why it's important to learn about privacy, how do we realign the challenges that you explain and the reality that we want to make privacy meaningful? What's your opinion on that?
Yeah, and it is tricky because of the aggregation problem. With the fact that a lot of these harms could be very small by each individual company. The problem is scale. We have just an immense scale these days with so many companies gathering and using so much personal information. Obviously there are some companies that eat a lot of data and do a lot of things, but a lot of times there's just so many out there, and it's increasingly hard to manage one's privacy because the scale is just too vast. There's just too many companies. One thing just to manage it with one or two companies, but with all of them, it becomes really hard. And so it's no imposition if you just have to click unsubscribe on an email. Well, if there's only one entity sending you that you have to do that to, okay, that's not that big of a problem. But for everybody at scale, it becomes really burdensome. And this happens a lot. And so each individual company and say, hey, we're just doing what we should do, but this doesn't scale well. And so ultimately, the law tends to focus on each individual actor, but not the collective. But it's the collective that really drives this harm and makes it more significant. It's like death by a thousand cuts. And so the law needs to kind of get around this difficulty, because or else for each individual actor that they'll just do what they do, thinking, hey, we're not doing anything that bad. It's small, but then collectively everyone is being harmed. So there's that issue. And then the other thing is sort of this larger the larger social aspect to privacy harm. Privacy doesn't just affect one like isolated individuals. It has larger social effects, and we see that with the Cambridge Analytica and with other types of issues where they have societal effects, and certain data is interdependent in a lot of ways. So the law's existing solutions to this are often very individualistic, individual focused, when I think they need to also focus more on the kind of larger social implications of privacy problems, which I think is a common theme in the scholarship. It's been a theme in the scholarship for 30 plus years. Scholars have pointed out that privacy obviously affects the individual, but it's not solely an individual issue. There is a social component to this, and larger harms on society that the law needs to address, and that the law has been way too focused on the atomistic individual. I think what we're seeing today is that, with AI, is that the shortcomings of privacy law that folks have pointed out all throughout the years, myself and several others included, really are showing their deficiencies when we see AI. Which is a problem that we really brings the kind of social dimension right to the fore. And so I think that AI really shows how some of the limitations of privacy law in addressing harm really limits it, especially as we move into the world of AI and these very complex algorithms at a dramatic scale.
I agree with you, and on the point, and complementing a bit on the point of harm and definition. So I think now with AI, if we think, okay, artificial intelligence, it sometimes or when we discuss harms of artificial intelligence, we question what is to be human. So if there is a machine that starts helping us to be efficient, or there are tools that we can use to substitute a human being to make a human being more efficient. So what it means to be human. And in this point, we come back to privacy. And if we talk about, like Professor Luciano Floridi, privacy as human dignity, he equalizes the two values, or privacy as something much broader than data protection. Let's look at data transactions and data cycles. So I love that. In the sense, I see a lot of intersection between the two fields. when we look at privacy as protecting human dignity. Because when we have data transactions ongoing all the time and many service providers collecting and processing data, these processes of data collection and processing, they're not only transactions, they start interfering what it means to be human when every decision is made through an intermediary who is analyzing and predicting and profiling us and deciding what will be next and deciding who will be chosen, and then what it means to be human, where are the choices. And I think in this sense, privacy, and we will talk about that again in the last section, but in this sense, this broader notion of privacy, which is more connected to privacy as a human right and privacy as human dignity, it's great to help with AI issues. Because still, if we look at AI, and now AI is with the whole hype, but some of the things, the big themes is what it means to be human. What are we protecting? And I think that some of the aspects it means to protect human dignity, and I think privacy is very good at. Although laws don't treat it as this way, I think privacy is a great tool to bring this idea of human dignity. So let's now focus more on this, as Professor Solove introduced this topic of privacy and AI. So let's talk about some specific privacy harms and their relationship with AI issues. So one of the harms is reputational harm. So I wanted to discuss a little bit reputational harm in the context of AI hallucinations or AI disinformation. So let's recap. These are the 7 privacy harms that they are proposing. So physical harms, economic harms, reputational harms, psychological, autonomy, discrimination, and relationships. So let's talk about reputational harms. I've been discussing in the Privacy Whisper and on social media about AI hallucination, and now AI professionals, they don't like this term anymore. They prefer AI misinformation, and what it is. So most AI systems, let's say large language models like ChatGPT and other AI-based chatbots, they have a rate of hallucination or misinformation. What it is, you ask something, and it will sound very convincing, but it's a total lie. So there were many cases. So if you ask, oh, Professor X, which books did he write? And then it was a list of fake books. And some journalists, they are preparing to interview. I saw with Professor Ryan Callow, he said that some journalist was interviewing him and asked about he was attending a congressional hearing or something, because the journalist checked in ChatGPT and he was not going to go anywhere. And also there was some other cases, some recent cases of the lawyer recently that I posted about it as well. He was writing a legal brief, and then he cited cases that didn't exist. So now he's being punished by the judge. So the judge was, wow, so you cited some cases that never happened. And now the lawyer is suffering the consequences. And specifically about reputational harm. So these cases, let's say they were, lighter, but there can be really AI misinformation that causes harm. For example, there was a recent case of a lawyer that was being falsely accused by ChatGPT of having committed a sexual assault. And and as the ChatGPT is very convincing, there was it invented a whole story of when it happened and in what context. And the lawyer raised the issue. Look, it's a criminal accusation. This ChatGPT is coming up with this topic, and who will be liable? So it's very uncertain. OpenAI threw ChatGPT into the void. Now everybody's using to whatever applications people want. And okay, this lawyer said that the chat started outputting that he had committed a criminal offense. So my question and the topic, I think, is very important. So you proposed a reputational harm. And how do you think that this reputational harm in the privacy sphere could help us tackle issues now with, let's say, this example of the lawyer in ChatGPT, so AI misinformation? And also, how should we treat liability? So if we use this privacy-based reputational harm to this context, how could courts think about it, or professionals think about it? If maybe someone in the audience here is a lawyer and saw something happen, do you see a practical application with existing laws in this case of ChatGPT?
Yeah, well, I think that the law has generally, had a long-standing recognition of reputational harm. I mean, we've had defamation law for centuries, so we do have a firm basis in the law to provide some protection. When it comes to the story about the lawyer, I think that really doesn't involve a person's identity or reputation. It's not really saying something about a specific person. So that body of law wouldn't help. I mean, I think that the lawyer, essentially, committed an infraction against the court with bad
Mhm.
lawyering. You can't cite made up cases and should be punished. And the dog ate my homework excuse, or the dog wrote my brief excuse. Well, AI wrote my brief. It's absurd to do that, and I think the lawyer should be punished. When it comes to the hallucinations about people, that's something that's a common thing. I went into chat GPT-3 and so write a bio of me. So it wrote this bio and actually wrote a false but wonderful bio. I got a PhD from Berkeley. It gave me a clerkship with Judge Guido Calabresi. It was really nice. It's like, cool. So I liked what it did. It was great to be awarded a PhD by chat. Now, I think that some of these problems can be fixed. It could obviously be programmed, and ChatGPT 4, which I haven't had a chance to play around with yet, might have fixed this. I don't know. But it could certainly look and say, hey, don't make stuff up. Look for authoritative sources, because search actually has kind of figured this out. How do you find the authoritative sources? Just look for official bios and draw from those. Don't just make it up. So I think it could be programmed to, eventually do better fact checking, to check it against different data sources, to try to, and of course that could still fail. You could still have instances where, it looks for the authoritative source, but, can't quite identify it correctly and so on. But I expect that problem to improve. When it makes mistakes, you apply the existing law would say, if you are, asserting something to somebody else and holding it out as something that is true, and it's not, it's false. You can sue for defamation if it harms somebody's reputation. You could sue for false light if it causes someone emotional distress. So if somehow I was distressed by, being given a PhD, I could say that's a false light. Or if it said something bad about me, I could sue for defamation. And I think that, there's, the law has some remedies for those kind of things. But I ultimately suspect that problem will be improved upon in the future. But there's another scary aspect of where these technologies could impact reputation, and that is when people use them deliberately to try to create fakes. This is the deep fake problem, where people will try to create fake videos, fake porn videos of people, fake videos of people saying things or doing things that they've never done, fake photographs. We're seeing this occur. And the ability to spoof and fake is going to dramatically increase, because technologies are getting better and better about masking those little clues, those little things that give it away. And so as this gets better and better, it's going to be really hard to tell what's real and what's not real. And then this could really damage people tremendously, to have all these fake images and fake videos and voice spoofing. I mean, you can spoof someone's voice and make it sound like they're saying things. And so I think that this is a scary future, because it will enable anybody, people with malicious motives, to do things to damage other people's reputation, versus just the hallucinations of a chatbot. And that scares me a lot, because these are malicious actors trying to do this, spread this information, and it's someone sophisticated, they can spread it in ways that cloaks their identity or even makes them difficult to trace. So this stuff can get out there. and then it's really hard to find who did it, and ultimately also can be tricky about cleaning it off the internet when it starts to circulate.
And specifically about, let's take the example again. And you see the coincidence, two lawyers. The first lawyer was the one that made the mistake, and the second one was there's some, the ChatGPT has something against lawyers. We need to check that. It's worrying. So specifically about the liability, well, because it's ChatGPT or AI-based chatbots, they're not search engines. So what if a journalist says, I had good faith because I checked in ChatGPT, and that's what it was written. It was very convincing. So in this sense, I think it can be another level of trick. Also, who's when there is search, there are websites. You search something on Google. Let's say there is a list of websites with links. So liability is clear. So you come here, this website, you see, is it reliable? Is it not reliable? And I think what some people are still, and that's why we saw the lawyer case, the first lawyer, the one that made that wrote the legal thing with the fake cases. I think people are still, they don't understand that it's just a language model. So for some people, it's, and I wrote about it, it's like an oracle, right? It spits out the right answers because it's so concise, and it looks like it digested the whole internet. So for some people, it looks very convincing, and it sounds very anthropomorphizing. So it says, this is according to sources, and it sounds convincing. And for some people, they will say in good faith, listen, I checked, and this lawyer, it was written a very convincing story that this lawyer committed sexual assault. So do you see, would it be, who would be do you think would it be possible to say that this person had good faith? And because we are still in this transitional phase of understanding how to deal with technology, and so this would be a good faith excuse, and I don't know, nobody would be liable. Oh no, we should this part, because from what you said, I understood that the liability would be who used the data. So if I use ChatGPT and I have a false accusation of someone committed sexual assault, and I'm a journalist and I publish it, I will be liable for the reputational harm. Do you think there could be an argument of someone, maybe a trainee, a journalist that is beginning, or someone in another context that said, really, it's a good faith. I checked in this tool. It provided me a whole history, and I don't think that there was good faith. I thought I was really researching something that makes sense.
Yeah, well, it's complicated because a couple things is that I think that artificial intelligence is actually a little bit of a misnomer for the technology that's out there. Everyone's calling it AI. It's an algorithm that simulates intelligence, but it's not actual intelligence. It's not smart. It is simulating. It's trying to pretend and mimic how a human would talk, or a human would respond, or a human would write. But it's still lacking human judgment. It really doesn't have judgment. It just tries to look at patterns of what's out there and mimic. So I think that it's being held out as this kind of magic, but it's not magic, and it doesn't quite, it's not the sentient robot out there. So I think that it's unfortunate that I think we're calling it something that it's not, and that might confuse people. People might really think that the simulated intelligence is real, but it's really not. And so we might say, okay, we can forgive that. People might be operating under wrong assumptions, or really thinking that that something, not really understanding what's going on. I think on the other hand, there is a little bit of common sense. I mean, I think that lawyers and professionals need to be a little bit more on the know. I mean, you wouldn't want your doctor saying, "Hey, I'm going to come up with a operation procedure or a diagnosis just by having Chat GPT generate whatever it makes up." We expect that they understand, when they use a technology, when they use a tool, they should know how the tool works, and should really understand it before using it. Especially if they're a professional. For just the average person, they might not really know, they might not fully understand. And I think the companies that make the technologies, pump up the magic, and they want it to look magical. They want people to think it's AI because saying it's AI is sexy. Uh, so they want that kind of excitement rather than just, oh, it's just an algorithm faking it. So I think they're responsible in certain ways because they're putting it out there without the adequate disclaimers, and maybe they have them but they're buried. But the hype of it and everything else, and the reason why it's become so popular and so exciting is, I think, due to exploiting people's full understanding of how it works. It's trying to create that magic, and then if you create that magic and you try to lure people into using this, and don't adequately educate them, people are going to think it's true. People are not going to realize that this is all a hallucination, or that a lot of these facts are just made up. And I think the companies bear responsibility for what they've wrought, because they are contributing to that misunderstanding. It's just like if I make a product, a tool, and I kind of push people to use it in a certain way, and that way is dangerous and harmful to others. I'm responsible for my creating the tool and then fostering its misuse. And I think that's what's going on with a lot of the AI now. And I think there are responsible uses, so I don't think it's per se a problem if something is made up. So if I say, hey, make up a story about a person, because I want to create a fictional account of William Shakespeare. So make something up about Shakespeare, and it does. That's fine. That's what the tool is doing. But if I say, hey, I want to know more about a real person, and it sends me something that's false, now I'm under an impression that I'm getting something that is an actual, true account of them. I'm getting actual information, which is what happened to the lawyer. The lawyer said, I want actual cases. I want actual law. Help me write this brief. The United States is not make up a fake brief with fake cases. Well, if the technology isn't clear what it's doing, I think that you're creating a dangerous tool without adequate warning.
And specifically about, I agree with you, and I have my point of view is paternalistic in this sense of acknowledging that there is information asymmetry and power asymmetry, so companies should be responsible. And also, if you think specifically about ChatGPT, the answers comes in the first person, I. So this is the beginning. It should be perhaps something that to make clear that is. They make it conversational, so it's a chat. So, but also the chat format and answering as I, according to as a large language model, I cannot. But this I, it brings the idea of an entity, right? So I think it's also an interesting way. I would be against it if I was the regulator. I would say that the answers, the output of a large language model should be the system, the answer provided by the system is something more impersonal, to give this idea that it is a statistical tool, not an entity or something that will give you some type of knowledge or human, something similar to the human being. And continue. Let's move to the next point. I think it's related to what you said about the fake thing and deep fakes and everything fake. I think it's very important, and I brought a question about that. And related to autonomy harm. So I'm fascinated by this topic of autonomy. I think it was also part of, so my master's thesis I wrote about autonomy preserving protective measures to improve consent in privacy. So today I think it's a horrible title, but okay, it was my master's thesis. But I love the idea of autonomy. I think autonomy is something very important that makes us human, the ability to choose what life we want to have, how do we want to act, what are our choices in our way in life. And so I want to discuss a bit using the idea of autonomy harm in privacy to fight dark patterns in AI. So I wrote about dark patterns in privacy, the idea of UX tricks that make people share more data. And recently, in the Privacy Whisperer, I started developing this idea of dark patterns in AI. So I define dark patterns in AI as two main types of practices. So first one would be deepfakes. So AI applications that make people believe that something is true when it's not. So, for example, that fake image of the Pope with the white coat, or fake presidents hugging themselves, or the fake image of the Pentagon on fire, and also the example that you mentioned of revenge porn and fake pornography to damage someone's reputation. So this is all about fakes and trying to using technology and AI technology to convince people that something is real when it's not. So this would be the first category of dark pattern AI. And the second one I'm calling anthropomorphization, which would be AI applications that make people believe that there is a human behind. So the typical use would be like apps like Replica or AI companions. And I heard that Snap also has, if you log into Snap, everything, and maybe a chat GPT in some level when it answers as I. So it's a human way to behave. So anything that an AI system, any characteristic that can make it more, or can try to pretend that there is a human behind. So this would be another type of manipulation. So what's in common between fake and anthropomorphization? Those are applications that confuse people. They manipulate people. It's normal people, because the technology is so precise and so good in hiding the as you mentioned, the little glitches that would help us distinguish fake from truth. Technology is so good that now I really personally, that image of the Pope, the first time I saw it, you saw it, the Pope with the fluffy coat that was viral. I look at that image, I was sure, I said, wow, the Pope is very fashionable. And then it was fake. And then more recently, much more dangerous, the image of the Pentagon on fire. It could lead really to a war. You can imagine a fake Twitter account tweeting a fake image of the Pentagon saying that X country has bombed this. So let's talk about autonomy harm in this context. So we spoke about all those fake that AI can create, and this is a problem. And I think we are already having this problem. What's fake and what's not? It's every time I open any social media, I look at images and videos. Say, is it fake? Is it AI or not? So a central issue in these dark patterns is the interference with freedom of choice and accuracy of choice. So what's the relationship with the privacy area? So how do we make the breach? So I think the Replica case, so the Italy Data Protection Authority, they banned Replica, this AI companion. And Replica was, if you look at the website, it was an app that they were marketing it as you can find your lifelong partner. And people were describing how they had a relationship with AI, and you could choose the avatar, and you could talk with the avatar and have they kind of really romantic. If you look at the marketing, they were branding it really as even sexual romantic partner. And the Italian Data Protection Authority banned this app on the grounds of being exploiting vulnerable populations and children using it. So because it was so intimate, and you can imagine with this fake appearance of there being let's say an AI boyfriend or AI relationship, people were sharing whatever intimate information, and vulnerable people meant people in a mentally vulnerable situations and children. So the Italian Data Protection banned it. And I think that there are other situations in which those fake images or videos or anything that tries to pretend that it's real when it's not will interfere in human ability to choose and to decide what's true and what's not. So from your point of view, the idea of autonomy harming privacy could be useful to tackle, for example, the deepfakes, or if there is an image that starts a movement or even a democratic issue, could we tackle those type of problems with autonomy harm in privacy as you proposed, or those are two separate things?
Well, I think it sort of depends. Privacy, I mean, not all AI problems are privacy problems, although there's certainly a big overlap. If you're doing a Venn diagram, they would overlap, and there would be parts where, AI harms diverge from privacy ones. So if it's something dealing with, some event or something that's not about a person, then it might not be a privacy harm. But if it's trying to create a fake image about an event to influence a person, to get a person to do things, to get a person to share information. So let's say I spoof something about a city or a house being blown up, to scare a person into, oh my gosh, do you have loved ones in that place? Will you give me your information so I can give you more? Then that does involve a manipulation of a person to gather their data, or to have them act in a certain way. So anytime you're kind of acting on a person to try to change their behavior, influence their behavior through the use of these tools, I think you are into the realm of privacy in certain ways. You're trying to manipulate or control, shape behavior, and I think that these tools can help do that. But there are many other ways, without these tools, to do it as well. You can manipulate and coerce behavior, with other things, not necessarily just AI, but there are AI tools can be used for that purpose. When you're using it for that aim, if that's what you're doing with it, then I think it does uh, involve privacy problems, because you're trying to trick people. That's what the dark patterns are trying to do. They'll either try to trick people, or they will try to create unpleasant or time consuming or difficult situations where, or choices where, if you want to do the privacy protective thing, it's going to take you a lot longer. It's going to be more confusing. It's going to be hard to do. So they'll either make it a pain to do it, more painful than just sharing the information, or they'll try to deceive. And I can help, especially on the deception front of, how do you make it deceptive. But also you have you can use AI to call people and spoof a human, pretending like it's a real person that you're talking to extract information or to trick people in certain ways. Or AI chatbots, and you don't know, am I talking to a human, am I not talking to a human? Who is this is programmed to try to impersonate a person. And I think it is a problem if I'm talking on the phone to someone, or having a video conversation with someone, or a chat with someone, and they're not a real person. I'm wasting my time. I'm being deceived in my ability to communicate with someone else. And I think that does impinge on expectations, which is an impingement on my autonomy, my freedom. It's a disrespect for my time and effort. I have a false consciousness about who I'm dealing with. And it's all fake. In a way, it's kind of like an analogy might be made to the Truman Show, where this movie where this guy was living in this constructed bubble, and all his friends and all his and his spouse were actors who were hired and paid, and it's all fake. And he's a kind of like this thing, being fed stimuli to see what will he do next. And if AI is kind of doing the same thing, it's just in a way, right? It's very similar to spoofing things that we interact with, to get reactions out of people. And so yes, I think there's a harm there.
And do you think that current law is mature enough that could be immediate application, and it would have to be like legal gymnastics from lawyers? Do you think the law is ready, or we need more, let's say, more time?
Law's never ready, and law's never been ready. It's never been mature. Law is very immature. And law is basically a 2-year-old toddler having a tantrum. But I do think that there are aspects of the law that have a lot of power and have a lot of promise. I think that there's with a robust imagination, the law can get there. The law can help. The law always is going to have this catch-up problem. It's always going to need to develop, but It is possible. There are aspects of the law that can work and do work. I mean, one thing that Danielle and I discuss in the privacy harms article is that there are things in the law, cases and doctrines that could really recognize privacy harm if they were developed. And I think that there's a lack of imagination sometimes with the lawyers bringing the cases, that they don't see all the potential in the law and don't bring that up and show how this already exists in the law. So I often look at the papers that lawyers would submit, because I used to do a lot of consulting, and I saw what was done, and I really just like so much left on the table, so much not mentioned to courts that could have been possible if the argument had been made well, and if the right cases had been brought to the court's attention. And also, there's a failure of imagination on judges as well, and legislatures, where they don't, see, they don't spend enough time really thinking about things, or learning about all the different aspects of the law. Law has a tremendous power, but you have to imagine and you have to think big. And one thing is, I see that often that's not the case. I mean, right now, states are passing all these privacy laws inspired by California, and a lot are, kind of like watered down versions of the California law. Well, why not be creative? Why not sit there and think about this issue and really come up with something new? Stop just cutting and pasting, doing what's easy, and actually become familiar with the issue. Maybe consult with some experts and scholars and people who've thought about this for a very long time to come up with something that could be really good and effective, rather than just, oh, okay, well, this state did it and that state did it, so let's just copy and paste it. So it's in a way, like, AI is more imaginative than legislatures and courts sometimes. So I think, like, with a robust imagination and seeing the potential of the law, it really can develop. But you need that component to get it to mature. And I think, unfortunately, the law still has a long way to go, because the law is stuck in some old ways of thinking, with some old approaches that just don't work. They don't scale. So, we've got our work cut out for us.
Beautiful message about the creative power of underused creative power of law. And I think so. Let's. I will skip one of the questions, otherwise we will go. We will not have time for for the questions from the audience. Let's talk a little briefly, because Professor Solove has another webinar next week with Omer Ten, and who's the other person I forgot? The other panelist.
Yeah, it's going to be with Brenda Leong and Omer Tene.
Yeah, about AI. Is AI policy a privacy issue? So I don't want to cover his other webinar, but I want to close our discussion just with the. I think this topic is great, and I think privacy professionals around the world have this doubt, and I think now you see the AIPP is. No, the IAPP, sorry. IAPP started the AI governance, and privacy professionals are really diving deep into AI issues and AI governance and AI Act. It looked for Europeans and for anyone working with European law. If you work with GDPR, it flows so naturally that you're going to work with the AI Act too. So there is this issue of really what's the intersection, and we started the conversation with this topic, right? How can ideas of, let's say, broad ideas of privacy and protecting dignity, how can we use this already set infrastructure and concepts and even regulatory powers to help with AI issues? So let's just do something brief. So what, in your view, are the main ways that what we have already for privacy, both laws and the privacy programs and privacy professionals, and maybe even privacy certifications and all the infrastructure that we already have for privacy? How can we use this, what's already done, to influence or to help with AI governance, or to tackle AI issues? On mainly, let's say, AI issues could be easily solved with the help of privacy. What's your opinion on that?
Yeah. Well, I think that privacy has an infrastructure and laws and professionals who are thinking deeply about these issues, and so I think that's great to draw from. That doesn't mean that we can just take uh, existing privacy laws and apply them, and they're all going to solve everything. I mean that's definitely not the case. I'm going to give a preview of what I'm going to be saying in the webinar, which is that while it's certainly true that we can't just fold AI into privacy and all the privacy laws and all the approaches that privacy programs do are just going to magically solve everything for AI. They won't, because it's not exactly the same. But there's similarities, and there's a benefit to tap into the privacy infrastructure. First, and with a lot of companies, they don't have anyone else who are thinking about the issues, the ethical issues about data use, collection, and so on. And so the privacy team, they are focused on these issues. So I think it's good to draw upon them until we have a whole separate group of folks, focused just on AI. Who are you going to turn to in an organization? Well, the privacy officer is the one who, or the data protection officer is the one who is thinking about these larger ethical issues and is sort of already in that space. So they're a good person to turn to. Now, it doesn't mean we just take out their existing hammer and start just using it, but they at least have some of the background to understand these ethical issues. So they're a wise person to turn to for help here when we don't have anyone else to start thinking about these issues. So I think it's a natural thing for privacy professionals to start trying to tackle. But as you tackle this problem, I think that it's always good to do so with an open mind, to kind of look at it, to really understand it, to think about its problems, and not just kind of dust off the existing laws and tools and think, okay, we'll just apply these mechanically. It always starts with a kind of deep thinking and study of something to really understand it, and then see when can we use existing tools and when do we need new tools or need to think about other things. But I think that we at least have a starting point, and I think privacy is a good starting point because we built so much law, so much scholarship, so many professionals who have been thinking about it, conferences and events. There's all sorts of there's a lot there, and I can analogize or to the early days of privacy. When I started in the late 90s and early 2000s, none of this infrastructure really existed. There were only a few scholars. There wasn't a lot to read. There weren't that many events. They were just starting to be. The IPP didn't exist. You had hardly any privacy officers or privacy programs or even privacy lawyers in firms or anywhere else. So it was a very different world. And it was hard because there was very little to go on, very little guidance. Now that we have this infrastructure, it's tremendously valuable, and I think that we can tap into its power. It can really help in digesting these issues and understanding these issues. And so it's not, we don't have to start on, I wouldn't say a blank slate, but a very empty slate. With AI, we can tap into privacy, and then as the issues, there are differences, we can go down those paths and explore it. But at least start from something pretty robust and developed. And I think that's a good thing that we have what has arisen in the last 25 years. It's quite astounding, and there's a lot of thinking and good wisdom to be found among scholars, among privacy professionals, among policymakers. I mean, there's a lot there, and I think that it would be wise to study it, look at it, and use the infrastructure that we have as a launching pad.
I agree, and I think on a practical level, especially if some people here they work with European law too, there will be intersections and application of there will be situations in which both the AI Act and the GDPR will be applicable. So there will be certainly communication and a joint strategy to do the impact assessment for AI and for GDPR and privacy impact assessment and the AI assessment. So I think also in terms of practical compliance, that from what we have so far of the AI Act, there will be a lot of intersections. So in any case, I think those professionals, if it will be the same professional in a company or different people, they will be. I think there will be communication and joint strategy to solve issues. So I think now we finished the main part of the discussion. I saw some people commenting here that there were issues with the video. I hope it's solved now because we are here and it didn't finish yet. So now from the audience, if you have questions, please write here. Let's try to answer, let's say 3, 4 questions because we are getting late here. So if you have questions, please post it now on the comments. Then I'm going to read a few of them. So Zander Arnaus asked, would establishing a specialized expert agency for digital technologies help policy keep pace with technology change? What do you think? Would?
I'm of two minds about that. I mean, I do like the idea of a specialist kind of looking at these issues. On the other hand, I also like a kind of bottom up, dispersed approach. Because one danger, if you have one agency to rule them all, one that's just focused on it, they can get, myopically focused on something and fail to see some interesting parallels to other areas of law. So I think that more imaginative thinking involves thinkers from different perspectives. And also, I also think that for dangers of agency capture and other influence, having many different sources of policymakers that are on the beat, enforcing, thinking about these issues, developing policy can be a good thing. I mean, it's messier for sure, but it can be good. Now, I think that certainly there's a great benefit to having policymakers who are really steeped in these issues and are experts. But I don't like that to the exclusion of having many different agencies and others involved. So I'm happy to add something like that, but I wouldn't want to unify everything into one entity and then not have the others also on the beat looking into it, because I think there's a great benefit despite the mess that it can lead to.
Okay, I agree with you, and I think it's more creative power and more decentralization is better. And I think that there were various questions. So one here, I mean, there was one interesting one that I'm not finding the person, but it was here. Syed Mohammed Azin asked, "Is there any possibility to recognize AI as an accountable person?" What do you think? Is there?
Well, I don't think it. I mean, AI is not really a person. It's just a simulation, an algorithm that's designed by an entity, and so a person or entity designs this thing to do a function. But I don't think that the AI itself is any kind of recognizable entity or wouldn't have its own agency because it's not intelligent. It's that's just all. It's a simulation. It's an algorithm simulating, trying to make it seem that we are talking to a person, or that there's someone who actually is a person on the other side, or who looks like a person, speaks like a person, but they're not a person at the end of the day. We're not there with AI like we are in sci-fi, where you actually have these sentient robots who think on their own and have their own emotions and their own desires. We're not there. And so I don't think that we recognize AI for anything other than a tool created by an entity.
Agreed. And the last question for today is from Philip Mason. How are ChatGPT hallucinations different from bad Google search results? This I
Yeah.
can start also, but you can start here.
Yeah, I mean, I think that a search results are ultimately search results are just pointing to these are things on the internet that an algorithm has identified as relevant, but they don't necessarily purport to be true. And I think in the context, it's not clear that there's any um, indication that the results are actually true or not. They're just things that on a search. Whereas in the chat GPT, you ask it for a bio, you ask it to write a brief. You're asking it for give me true information about somebody, and then it doesn't. That's different because you're asking for something different, and so that's why I think that there's a difference there.
I agree with you. And also the thing of the sources and the way I think the design and the product and the way people use it influence the way the technology or the developer of the technology should be liable or not. So that's it for today. Thank you so much. Before we finish, I want to thank you so much, Professor Solove, for being here with us today. I'm super grateful and happy, excited. I'm a super fan. Your work has inspired my advocacy and my PhD, and I think your contribution to the privacy community is unique. You're one of the most important scholars today, so I could not be happier to have you here today. And do you want to tell less something for the audience, invite them to follow you, to read something specifically? Any final message that you want to share with the audience?
Yeah, so I hope that you can sign up for my newsletter. I have a newsletter as well as a blog where I post stuff on my company's website, teachprivacy.com. So if you go there and you'll look and you can hunt around for where to sign up for the newsletter. That has information about my scholarship, events, and blog posts. I also have cartoons and create other resources. So if that's of interest to you, please check that out, and you can keep up to date by follow me on Twitter or LinkedIn, and you can also keep up with some of the things that I'm writing and doing.
Thank you so much. So everyone, thank you for joining. If you want to keep informed and to be informed about the next events, please sign up for the Privacy Whisper, www.theprivacywhisper.com, and see you next month in the next live event of the Privacy Whisper. Bye-bye.